Please be seated. Can I have counsel approach for one brief moment?
Ask the court to allow Mr. Zimmerman to waive his appearance for the hearing today. He's been here all day, as the court's aware, and he won't directly participate in these proceedings.
Okay, Mr. Zimmerman, are you agreeable that your appearance be waived for this rebuttal testimony of the Fry hearing?
Yes, Your Honor.
Okay, you may be excused.
Thank you. So going to follow Mr. Zimmerman out, so I will see you
Okay.
in the morning.
And Mr. Mantine, you may begin.
Thank you, Your Honor.
Mr. Owen, can you hear me, sir?
Yes, I can.
All right, Mr. Owen, you were previously placed under oath, and you still are. You understand that?
That's correct.
Mr. Owen, I had requested that the court consider your testimony for rebuttal for some very narrow purposes. The first of those is, you recall during your prior testimony that you were asked questions about the process that was described by the defense counsel's looping, whereby the sample of the screams was alleged to be improper, that when added together. You remember that series of questions?
Yes, I do.
And do you remember that you were asked about whether you had verified whether that would cause a problem with the software recognition or not?
Yes, I did.
And did you check on that?
Yes, I did.
What did you find out?
I found out that, first off, looping is a term that was used by Mr. West, not by me. That the software, if it's too short a sample, will not work. It'll throw a flag up and say...
Just a second. He can't hear
But
you.
Just a minute, Mr. Owen. Hang on. There's an objection.
What's your objection?
This is hearsay because this witness is now being asked to testify about what somebody else told him that supposedly is an expert. And I will have no opportunity to cross-examine whoever that person was. This witness has already acknowledged he's not, insofar as the software itself is concerned, doesn't understand the math behind it, and it's obvious by Mr. Manti's question that he sought outside counsel of some sort. So I object.
Response.
Actually, Mr. Owen has not acknowledged that he's not an expert. In fact, I think he's to the contrary. But that aside...
No, I think that what Mr. West meant was an expert in that software.
As to whether or not he can program it, I believe he admitted that he could not do that.
Okay.
I agree with the court. However, the reason that this should be admissible is in rebuttal to the allegations that he had not, that he had talked to the improper person before. In other words, it was used before in that very context. And so I believe I should be allowed a fair response to that, even if the matter is technically hearsay, because it's in response to hearsay elicited by defense counsel.
Okay. When you have hearsay and there's no objection, the court doesn't have to make a ruling. When there is an objection based upon hearsay, the court has to make a ruling. So since something may have come in that may have been hearsay and there had been no objection to it, doesn't mean that you can't now make an objection to hearsay. So Mr. Owen cannot testify as to what his conversation was because Mr. West would not be afforded the opportunity to cross-examine that person who gave him the information. Thus, Mr. Owen's interpretation of the conversation is what the court would hear, and I do not feel that that is proper, so I will sustain a hearsay objection.
Yes, Your Honor. I'll move on to the next section then. Mr. Owen, do you recall the series of conversations that were had the last time you testified regarding, well, Did you have occasion to observe the testimony of Dr. Wayman, who testified in the last section of this hearing?
Yes, I did.
Do you recall seeing that he was shown some sort of paper that was purported to have been authored by yourself?
Yes, I did.
Okay, and do you know which paper it is we're talking about?
Yes, I did.
And was that authored by you?
Okay, and your objection is?
Dr. Wayman, the testimony was that Dr. Wayman received this document from me. And there was some question, in fact, an issue raised by Mr. Manti about what document it was. And then that was clarified through some questioning that indeed that was a document that was provided to the defense by the state in discovery, which I then forwarded to Dr. Wayman. Dr. Wayman's testimony was, as I recall it, that because he received it from me and I received it from the state, he believed it to be connected with Mr. Owen. I do not recall him ever having said that he believed Mr. Owen wrote it. In fact, it was just that. This was a document he received in connection with Mr. Owen's testimony. He reviewed it, he commented on it, but never claimed that he knew that Mr. Owen wrote it.
Okay, and Mr. Manti has established through Mr. Owen's testimony here today that he did not write this document, so he may inquire as to why he had this document and why it was produced.
Judge, specifically, it was referred to and referenced as, during the testimony, as an Owen report, a report by Tom
Well,
Owen.
you could clarify that.
Yes. You're talking about the document that was referred to by Dr. Wayman as a Tom Owen report?
That's correct.
And is it in fact a Tom Owen report?
Absolutely not.
Are you familiar with Dr. Wayman and Dr. Nakasone?
I wasn't familiar with Dr. Wayman. I am very familiar with Dr. Nakasone.
Okay. Have the two of you had occasion to cross paths in the past?
Yes.
What is your understanding of the relationship between Dr. Wayman and Dr. Nakasone, if any?
From what I understand, I believe that
Okay.
Mr. Wayman,
Wait,
Dr.
could
Wayman...
you
Just a
please-
minute, Mr. Owen.
No matter how loud I talk, he's not going to be able to hear me, I don't believe. Your objection is?
Relevant. What does it matter what his understanding of the relationship between Dr. Wayman and Dr. Nakasone might be?
Okay, I'm going to overrule on relevance.
Thank you. Mr. Owen, please continue your answer.
It's my understanding that Dr. Wayman was employed by his contractor, who was employed by the FBI to help Mr. Nakasone with his super APHIS database, which included voice material.
Have you and Dr. Nakasone recently appeared on, I'll call it, opposite sides of a different case?
Yes, several times.
Okay. And no other questions, Your Honor. Thank you. That is the scope of the rebuttal here.
Okay, Cross?
Thank you. May I have that? Mr. Owen, this is Don West. Hi.
How are you doing today?
Can you see me and hear me okay from where you are?
Yes, I can.
Great. Let's talk about this document for a moment. The title of it is Comparison Parameters and Speaker Similarity Coincidence Criteria. Are you familiar with that document?
Mine says draft white paper voice recognition in law enforcement. Is that the document? Could you
No.
put up on the screen? Let me see the first page.
All right.
If
I'm
we're
going to
talking about the same
see if
thing.
I can hold it in a way that you can see it.
I'm not so sure what that is.
Would it help if I read any part of it, do you think? Do you have all...
Read-
Let me ask you
read the
this way.
Read the first paragraph.
I'll ask you this way. Do you have all of the paperwork that you provided to the state attorney's office in connection with this case?
Yes. Mhm.
The title of the document I'm referring to is Comparison Parameters and Speaker Similarity Coincidence Criteria. The first paragraph reads, the Easy Voice system uses two interrelating parameters of comparison, paren, first and second error types, close paren. The next paragraph begins with false rejection, FR, is a probability of error. Does that ring a bell?
The information rings a bell, but the document, I don't have it in front of me. I don't know which document exactly you're referring to.
The next paragraph says, is it clear that you didn't write this document? Is that evident?
I don't have it in front of me. I don't believe so. I thought I sent a document called Draft White Paper, Voice Recognition in Law Enforcement, because Mr. Wayman referred to, Dr. Wayman referred to various illustrations that are in this paper on page, that I'm looking at on page 3 and on page 2. Show me page 2 and page 3 on the screen there. And let me see if I can identify it.
I'm going to read the...
No, just show me the page, see if I can identify the pictures.
There's no picture on the second page. It begins with the title, The Easy Voice Biometric Analysis Algorithms.
We're not talking about the same document.
I'll skip a page. Well, let me skip several pages, actually, maybe because there's an illustration on this page. Of the document, it's page 7, and the first line on this in bold reads, Gaussian Mixture Models Based Method, GMM. And I'll hold that up for you.
My document here only goes to page 6. It's a different document.
I take it then you're unable to speak to this document or what it is?
Not without having it in front of me. Not at this time.
If I showed you the illustration on page 7 of my document, which is titled Gaussian Mixture Models Based Method, would you be able to look at the illustrations and comment on whether, in fact, these illustrations accurately portray the science of the Gaussian mixture model that your software uses?
Let me see there what you've got there. No, that's not correct. The document, I'll put it on my screen if you put it down for a second. This is the document here that I'm referring to, which is basically a sales document. And the document itself later became a full-blown sales document called Speech Pro Voice Grid, which was the name of the software before it became Easy Voice.
So the document that you have there is not a scientific presentation of how your software works?
No. In the sense that it's a sales document.
would you be able to look at the illustration in the material that discusses the Easy Voice system and the algorithms that the Easy Voice system uses and comment on whether the illustration is an accurate representation of the Gaussian mixture method?
I can't really say. I can't read it. Who's the document addressed to?
Well, unfortunately, it doesn't have a name on it. It doesn't have a letterhead. It doesn't have a signature at the end. But the content...
Is there a case site that's listed?
Case...
Like State versus Zimmerman?
Oh, no. No, it's got no identifiers on it other than it's a discussion of how the Easy Voice system works.
Are there any conclusions or opinions offered?
There are not any opinions offered that relate to this case specifically by name. So that doesn't... This is a document apparently you've never seen before?
I've seen the illustration, but I don't have any recollection of seeing the document. I don't know where it's from or what purpose that it serves.
Okay. You heard Dr. Wayman testify, I take it, that in his opinion, the Gaussian mixture model, as portrayed by the illustration on page 7 of this document, is fundamentally flawed because it's not.
I did hear him say that.
Do you agree?
I can't speak to. He was talking from a mathematical perspective. I can't speak to that issue. I'm not a mathematician.
Would you be able to look at this illustration, or could you explain to us how the Easy Voice system uses the Gaussian mixture model in its analysis?
Well, basically, that's what they call it, but
Could you
in
tell
reality, is the way I understand it.
Could you tell him there's an
Oh,
objection?
I'm sorry, Dr. Owen, hang on. Or Mr. Owen, hang on, I'm sorry.
We're now well beyond the scope of the rebuttal part of the hearing.
It is beyond the scope of the rebuttal.
Except with one minor caveat I would submit, and that is Mr. Owens being offered as an expert in this software. And I think I have the opportunity to explore whether he really understands it.
Okay, you had that opportunity when he first testified on behalf of the state. The state has now called him for rebuttal and was very limited in what evidence they offered in the rebuttal. And as such, the defense is limited to their cross based upon what the testimony has been today. So I'm going to sustain the objection.
Would it be fair to say, Mr. Owen, that you do not have a math background that would allow you to understand the mathematics, the algorithms that are the basis of the software your system uses?
Same objection, Your Honor.
Okay, Mr. Owen has already testified here today that he's not a mathematician and he can't comment on Dr. Wayman's testimony, and anything beyond that would be outside the scope of the rebuttal testimony that's been offered today.
I accept that he's not a mathematician, and I don't want him to comment on Dr. Wayman. I want to ask him, though, if he understands the math, understands the algorithm in the development of this software that forms the basis of his testimony.
If you could point to me where in the rebuttal testimony given this afternoon he has given any testimony in that regard, I will allow you to do that, but I did not hear any.
I would think for the purposes of Fry, the court would want to know all...
The court has heard the testimony of Mr. Owen when he originally testified, and both sides had the opportunity to examine and cross-examine him. He's brought here today for rebuttal testimony, and it was a very limited rebuttal, and by the rules of evidence, your cross is limited to what his testimony has been today. So the objection is
Thank you,
sustained.
Your Honor. I'm just processing it for a second.
I understand.
So I can ask the next question. You commented, Mr. Owen, that you and Dr. Nakasone have appeared in the same court case.
Yes, several.
When is the most recent case in which you've testified that Dr. Nakasone has also testified?
Well, we did. Neither one of us testified. It was in Puerto Rico. We both wrote papers. I did this case where I examined 5 phone calls. Let me finish Let me finish.
Let me interrupt you, just to keep the focus is all. I'd like to know the last case that you and Dr. Nakasone both testified in.
The last case was in Florida. It was Judge Moore down in Miami. It was a federal case, and I don't have the exact date in front of me, but it was a while ago.
Well, you're talking about a court case in Miami.
Yes.
In which both you and Dr. Nakasone appeared as expert testifying witnesses?
No, he had another FBI agent, a retired FBI agent, actually appeared to attempt to speak to the issue
Let me
finish.
Wait a second, please. If you would let the court rule. I'm sorry, Mr. Owen, if this...
Judge, I would ask that he be allowed to finish his answer.
I will allow him to finish his answer.
But his answer isn't responsive.
Okay, how is it not responsive?
Because he's basically saying that the case he was about to tell us of, both he and Dr. Nakasone didn't testify. I want to know the last case in which both Mr. Owen and Dr. Nakasone testified as expert witnesses.
Okay, could you please answer that question first? He can't hear me.
Mr. Owen, when was the last case in which both you and Dr. Nakasone testified as experts?
The case in Miami was an admissibility hearing, both for voice ID and to see that I would get appointed by CJA. That's what the case was about. It was preliminary. The judge ruled that voice ID was okay.
Wait, please.
Just let him finish.
I can't let him finish, Judge. It's not responsive. The question was, name the case and when.
Actually, that was not the question.
It is now. When was this?
But you're amending your question, and I am going to allow him to finish answering, and then you can ask your next question.
May I repose the question?
You interrupted him while he was giving his answer. He would like to finish his answer, so if you would...
The answer wasn't responsive because Mr. Owen wants to talk about the substance of the testimony.
Well, he's not to talk about the substance of the testimony. He was in the process of telling us what type of case it was, and I think he said it was an admissibility hearing, and he was cut off, and he wasn't able to finish that. So
May we ask him first for the year so that we can then go from there?
Yes, but please don't cut him off in the middle of his answer anymore. Thank you.
Mr. Owen, the
Yes.
case that you're going to be telling us about, where you and Dr. Nakasone testified as experts, when was that? What year was that?
It was in the 1990s. I don't have. Hang on a second. Jan, look it up on the testimony. Miami. I'm going to have somebody look it up for you.
And in the meantime,
let's
Judge,
just take a minute then.
and in the meantime, Judge, I'd ask you to be allowed to finish his answer that he was giving.
Okay.
I would object to that because of this. Because Mr. Owen said that he's only used this software for the last year and a half or so, and that he's used it, I guess, altogether in some version or another, maybe, 2 or 3
Your
years.
question...
This can't be the same methodology.
Well, but that was not your question. Your question was, when is the last time that you and Dr. Nakasone testified in court together? It wasn't what he testified about. It wasn't about software. and he was trying to answer, and your next question that you wanted qualifying was what year. I understand you want to go to the next phase, but I'm going to allow him to answer the first question. You may answer.
Mr. Owen, did you hear that?
Parts of it.
Okay.
But I can answer. I think I heard enough from the judge. The year was 1999. The judge was Judge Moore. It was a voice identification case, 2 calls. It was an admissibility hearing. Voice ID was admitted. My CJA voucher
Your Honor,
was
this is
admitted.
not responsive.
Let me finish, please.
Mr. West, please allow him to finish. Go ahead.
Okay.
You may answer.
It didn't go to trial because I did the test. It was the person's voice. He was guilty, and he took a plea. That was the end result of it.
Did you use the software in that case that you used in this case?
Sure, in that case, I used multi-speech. I also used multi-speech in this case, as well as EVP.
Did you use Easy Voice Biometrics?
In 1999?
Correct.
No one used Easy Voice in 1999. It wasn't available.
Thank you, Judge. Nothing else.
Okay, any redirect?
No, thank you, Your Honor.
Okay, Mr. Owen, thank you very much. Your testimony is concluded. Thank you, sir.
Thank you.
Thank you, Mr. Owen.
Thank you.
Does counsel want to proceed to argument on the Fry hearing?
I intend to do that, Your Honor. It also suggested a written argument. I have one of those compiled already.
Mr. West?
I don't have a written argument. I just haven't had time with the schedule that we
Well, then you may proceed with an oral closing on this issue.
Yes, Your Honor. I think it's the state's burden to
Well-
establish the admissibility. And then I would like an opportunity to respond.
I guess you're going to have to give it orally.
That's fine, Your Honor. If I could, just a moment. I'm going to begin at the beginning, Your Honor. This is the Evidence Code, Rule 90. I think it's 601, 602. Any relevant fact, any fact relevant to prove an issue is admissible into evidence unless the admissibility is precluded by some specific rule of exclusion. That's still the law as far as I understand it. I'm going to continue with the fact
Can
that...
you go back for a second? You have a citation out there.
Absolutely.
Thank you.
And in fact, what I'll do is, if with the court's permission, I'll just give you a copy of it so that it is all available.
Okay, thank you.
And I'll give counsel one, too, if you really want to.
Thank you.
Secondly, Your Honor, I'm going to cite the Searcy case. It's S-E-R-C-E-Y versus State. And just so there's no confusion, that's what the court can have in the floor. The issue of whether the particular analysis was performed in the proper manner, including whether sufficient quality control procedures were used to ensure the accuracy of the test results, is a question of credibility and probative value for the jury to determine. Florida law favors letting the jury sort out contested matters. Evidence is presumed admissible unless there's a specific rule that bars it. Mr. Owen, as you've heard him testify, is hired by the newspaper. He spent many hours analyzing the tapes in this case. He has years of experience. He's been accepted as an expert in many courts before, state and federal. The same software that he used in this case, he also used to determine that there was no racial slur uttered by the defendant, which was the initial reason he even got involved in the case. He also matched the defendant's yells to the defendant as he testified. The same methodologies as the others He listened critically. He did employ some form of the spectrographic visual. He did not use it or call it a voice print, and nobody does and nobody has in years. It's sort of a straw man that's been erected by the defense in this case. He did use the computer algorithms. He's analyzed screams before. These screams alone didn't match the defendant, although the other sounds, as I said, the defendant's reenactment yells, even when he, as he testified, elevated the pitch several semitones, the defendant still showed to be himself. The only thing that didn't match him was the screams. Exclusion, as he testified, is a much simpler process than actually identifying the voice. Mr. Owen did not attempt to identify the voice, despite the fact that a couple of the defense witnesses said that he did, including Dr. Wayman. And there were no flaws in the processes themselves. Dr. Reich also was originally hired by a newspaper. He has spent hundreds of hours analyzing these tapes. He's been provided with the forensic tapes from both the defendant and the victim. He utilizes a computer to assist him in oral and acoustic analyses. None of that is new or novel. He talked about informant frequencies, which can be reflected on the spectrograph, which actually even Mr. Wayman just discussed. He did say that basically he used a program to sort of filter out some noise and turn up the volume on some of the background sounds, which even the defense witnesses acknowledged there's nothing wrong with that. Taken together with those known factors, in other words, assuming a closed set of two possible screamers and the fact that the screaming stops right after the gunshot, he concluded that the screams were not the defendant, and he concluded tentatively that they were the victim, Trayvon Martin. I will repeat here the motion I filed earlier as to the audibility portion of Dr. Reich's testimony. That is not something that is subject to a Fry hearing. I maintain that position. I don't know that simply by accepting the testimony that the court has decided that that is the law that applies. The court is free to accept the testimony and still follow the law. Dr. Nakasone himself testified that oral listening, spectral, and computer recognition are all valid methodologies, and they are all methodologies that he himself used in analyzing this evidence. His statement was that he differs in his opinion, but he has no quarrel with the methodologies used in this case by the state's experts. If anything, and I think his testimony together with the other witnesses was that what's new here is this new working group, this one-meeting working group, this group that is attempting to sort of identify or start talking about vocabulary and standards. That's what's brand new. The stuff that got used, the things that got used, none of that's new and novel. What's new and novel is the sort of critique that we're hearing. It's not to say one or the other is completely invalid, but if there's anything that's being new and novel here, it's this criticism. Dr. French, point out he's never testified in a U.S. court before. Doesn't mean he can't. Doesn't mean he shouldn't. He did testify that all three methods have their place. They are all validly used. None of them are new and novel. He is not an advocate, unlike the working group that we heard from the other defense witnesses. He does not believe in setting these bare minimum standards for duration and number of words and such like that. He says, actually, consistent with what Mr. Owen said, that you need actually less evidence, less sample to make an elimination as opposed to making an identification. He had all the materials. He used different computer programs. He says that often he does analyze forensic samples, and they often are, in fact, workable, as opposed to some of the other defense witnesses. This one, he said, isn't suitable because of the screaming. Dr. Doddington has only testified once ever before. It was a hearing in Minnesota 30-some years ago. He has never analyzed forensic samples. He did talk about all three common methods of voice analysis. He said that you can become familiar with a voice by repeated listening, and a familiar listener still has the best chance. He was never provided the victim's exemplar here. He listened to the tape for 3 or 4 hours on his desktop computer. He did include analyzation by spectrograph. He said, in his opinion, a forensic sample, again, disagrees here with Dr. French, that a forensic sample is never sufficient. He talked about the concept of listener bias, and I will submit that there is the allegation, I think, by the defense is that Dr. Reich must have had some kind of listener bias wanting to hear certain things. I submit to the court, and the court can draw its own conclusions, there is a bias equally in the opposite direction of, and especially as it relates to Drs. Wayman and Doddington. If this is a forensic sample, we're not even going to bother, especially since it's a scream. Our bias is we're going to assume without even listening to it, that there's nothing workable there. They both said that. If there is a bias built in, I submit that's equally strong. That different communities can disagree. It is important that different scientific communities and scientists within communities disagree. That's how science progresses. Disagreement by itself is not a problem. He confused a little bit Mr. Owen with Dr. Reich. He is not aware of mandatory standards that are set in other fields, and he has not researched speech in depth. And he also said something that I think is a bit telling, and that when he runs into others with different views, that sometimes their attempt to be suppressed. That is sort of the idea of imposing minimum standards on people. Dr. Wayman, he's never been tenured or recognized by any U.S. court as an expert in anything. Again, doesn't mean he can't be. It just means that when we're talking about the particular witnesses in this case, these are things for the court to consider. He also does never, ever do forensic casework. He spent actually almost zero time listening here. I think he said under 10 minutes. He was never provided the victim's exemplar. He doesn't know what Dr. Reich's method was. He doesn't know what Mr. Owen's software is, and he based his entire opinion on an incorrect assumption about that paper. He complains that other people's reports aren't detailed, but he hasn't written one himself. He already formed an opinion, quote, the first time he heard it. He was, again, as I pointed out, inconsistent with even Dr. French. He comes up with legal conclusions. He told you about his disagreement with the federal courts as it relates to the fingerprint standards, and he also talked right here about whether or not the product rules, as far as DNA, satisfied the Fry standards. I understand he has a very strong opinion. He's a very smart guy, but he does try, I think those two things evince it very well, to go a little bit above and beyond where he ought to be testifying. He does talk about vague terms and lack of vocabulary, that is not uncommon, that people disagree even about the very same meaning of the very same scientific terms. That's part of his mission. And he even pointed out to the court that even the National Academy of Sciences, 2 years back-to-back, issued very disagreeing reports, almost in direct contravention with one another. And he told you he agreed with the earlier version and disagreed very strongly with the second version, but the second version is the one that governs. It is sharp. It is easy to look sharp when you haven't done any work. When you don't want to look at it, it's easy. Briefly, I know the court said that you have reviewed pretty much every case. I just want to make sure I don't leave any stones unturned here. I will point out that the law in Florida is that in the vast majority of cases, no Fry inquiry is even required because no innovative scientific theories are at issue. Fry sets out the test, at least for the moment. I will concede and acknowledge, of course, the court is aware the governor signed into law the statute which changes to a Daubert jurisdiction. That, of course, has not been adopted actually as a rule of evidence yet by the Florida Supreme Court. In fact, it's been, I saw last week, referred to several committees for comment on that issue, including the Code and Rules of Evidence Committee, which meets next week. In this case, in IBAR, and I would argue in this case as well, what we're talking about here isn't some new or novel scientific theory, in which case the Fry test isn't even really implicated. Which is really the new or novel idea? The court is not required to accept a nose count of experts. You can peruse different things and disparate things, including the prior judicial opinions, and decide for yourself whether the theory and issue has been sufficiently tested. That's the Ramirez case. So which is new or novel? The oral spectrographic computer models, or these new research-based standards that really don't even exist yet because they're still being bandied about in a working group. Only the general principles and methods are subject to Fry. It is not necessary that the expert's opinion be generally accepted. The nature of his conclusion is irrelevant, even if it's controversial, even if it's unique. Fry allows even opposite opinion testimony from experts relying on the same generally accepted scientific principles and methodologies. The opinion of the testifying expert need not be generally accepted. Lack of studies doesn't preclude admissibility and requiring sort of unanimity or a vast majority of noses counted, I think that the Florida Supreme Court has recognized that just sort of makes actual expert testimony useless. It's sort of a verbatim regurgitation of what might be in the literature somewhere as opposed to actual expert testimony, sitting down, doing the wet bench work, and trying to formulate an opinion. Where the procedures themselves are not new and novel, it is for the jury to determine the credibility of those expert opinions. I'm re-quoting Cersei, which I cited right at the very beginning of this argument, and I'll simply close by saying, Your Honor, if the evidence is really as bad and the methodology is really as bad as the defense believes it to be, then they ought to welcome the jury hearing about it as opposed to trying to keep it from them. I think the court should grant the ability to present that evidence to the jury and let them decide what is and is not the best evidence, just as we discussed during voir dire this morning. Thank you.
Thank you very much. Mr. West?
I too will be brief because I know the court commented that it's reviewed the case law extensively and that the court took extensive notes during the testimony. And I know that the court is familiar with what the scope of a Fry hearing is. But just a little bit of background.
Just one minute.
Oh, sure.
Thank you.
As the court is aware, we have been scrambling to try to get our hands around this testimony in this case. As the court's aware, Mr. Owen never did prepare a report. We made an attempt to take his deposition, but we weren't able to because we couldn't afford it. He wanted $3,300 to talk to him for half a day. By the time we brought it before the court, and Mr. Owen agreed to reduce his fee to a minimum of 4 hours, it was already, I think, a day or two before the Fry hearing was about to start. It was simply impossible for us to explore that in great detail. We learned of Alan Reich at the last possible moment under the court's discovery order. We got his report on May 10th at the end of the day. That was the first report. In fact, that was the day after we were supposed to try to schedule his deposition without even knowing at all what he was going to say. We got that, and then we tried to schedule his deposition, and he was ill. And we finally did part of a deposition on May 24th or 25th, somewhere around there, where we learned that Dr. Reich isn't done yet, won't be done, and won't even be done probably during this trial. At least he's not done yet. There's been no follow-up report. We still don't know what his method was, what his conclusions are, but we do know so far that no other expert has found any of the things that he claims to hear. We'll talk about that more in a moment, under the context of Fry and trustworthiness and accepted within the relevant scientific community. Without having received his preliminary report that the state had for almost a year, we took his deposition when he revealed the first one, the one that he did for the Washington Post. We got that sometime well after the report that we'd gotten on May 10th and after the deposition on the 24th, I think. We are absolutely scrambling to just get our hands around this, and we're not even there yet. But so let's start more from the Fry hearing, though. I'm just explaining to the court the challenges that we had asked for more time to explore this. We asked for an opportunity to let Dr. Reich finish his report and take his deposition and really know what he was saying, what his methodology was, because it wasn't clear from the report, to find people that could try to do what he claims he could have done. The contact with our experts was in that scramble over the last month, roughly, give or take. We had Dr. Holin's report sometime in April, but just a few days before his deposition.
Well, Dr. Holin's report has not been entered into evidence here, and neither has he testified.
Correct.
So the court is only going to consider that which has been entered into evidence in the testimony it received.
My point is this, that the state has the burden of establishing the acceptance within the relevant scientific community. They offered no experts other than Mr. Owen and Dr. Reich to essentially validate their own work in this case. There were no experts called, including Dr. Holin, to say, yes, this is what we do, this is how we can do it, when we can do it, what's meaningful and what isn't. So there was no effort whatsoever by the state to, in fact, bring a representative community of speech identification, speaker identification, or even speech recognition experts before this court. That's the backdrop to Dr. Nakasone. As the court will recall, Dr. Nakasone runs the FBI lab. He's done it for years. He's done it all his career somewhere, starting back with the Los Angeles County Sheriff's Office. He has testified. He now, in fact, he said they don't testify now because there isn't an accepted methodology in the FBI's opinion that is reliable enough to result in forensic testimony. For a long, long time, they endorsed, or they attempted to use the spectrographic analysis, the oral spectrographic analysis. The closest thing, I think, that Dr. Reich claims to have tried to use. And they gave up on it. 40, 50 years they've been trying. They have finally thrown the towel. It doesn't work. They've abandoned it. They've now shifted to an automated speaker recognition system. Dr. Nakasone said it's at least 2 years away before they would have any confidence that it's reliable, and it's certainly not accepted in the scientific community. That's the system that Mr. Owen used, the automated speaker recognition system. That's the computer system. George Doddington, Jim Wayman are absolute, distinguished international experts in that community. They know to the minute what's happening in automated speaker recognition. Dr. Nakasone runs the FBI lab. He knows it too. In fact, they work together on working groups to try to come up with some standards. Dr. Doddington, in his work with NSA and then as a consultant to NIST, funds, supervises, organizes the evaluation of these procedures. They invite people to submit their algorithms. They invite them to submit their techniques. For example, Reva Schwartz with the Secret Service uses the oral perceptive technique, and they submit them for real testing, real honest-to-goodness testing with clear experiments designed to see where the state of the art is. They wouldn't, in a million years, try to test the samples in this case because it would do them no good. They know the speech samples in this case, a few bits and pieces of somebody screaming is simply unsuitable for any kind of analysis in this case. And they can know that quickly. When you know what you're talking about, you know pretty quickly how to assess something. To suggest that George Doddington or James Wayman don't know what they're talking about because they don't run a private forensic lab for profit, that they don't know what's happening in the scientific community, that they can't tell this court, as they did, that this is a fool's errand. There is no methodology in existence anywhere in the world that can reliably test what we have in this case. They know it's a fool's errand because it's a waste of everybody's time. Or, if you try, the results are going to be unreliable. You can't get reliable results with it. Would we like to have reliable results? Yes, we would. The state's experts don't even agree among themselves. Mr. Owen took all these screams believing it was one person, stirred them up in a pot, ran it through a couple of times, and came up with some sort of opinion based upon which light lit up. Alan Reich says he hears George Zimmerman and Trayvon Martin holding a conversation. His report should begin, "It was a dark and stormy night." There's nothing scientific about that. There is no methodology in existence that allows that man to come up with what he said. Because if there were, Nakasone, Doddington, and Wayman and French would know about it. And it would be, in Dr. Nakasone's words, breathtaking. It would be worthy of a Nobel Prize. Something that doesn't exist. So, if these guys did it, they have created the most phenomenal methodology known in this industry. And it has completely escaped the world's preeminent experts. But there's Dr. French as well. Dr. French is a forensic voice identification expert. He does do this hands-on. He has a laboratory in England with several full-time employees. They did the work on this case. He also has an association with the university, where he's directed research projects of graduate students specifically focusing on screams. Can't be done. In fact, it's worse than they thought. You can't do it because it's garbage on the other side. He says it's ridiculous. He says it's absurd, and he has significant questions about what methodology Dr. Reich used, if any, frankly. The conclusions that Dr. Reich claim about the percentage of growth that Mr. Martin may have in its relationship to the pitch and all of that stuff is not founded in any science anywhere. He's making it up. He's making up the words that he claims to hear. No one else can hear them. He didn't use a blind listening panel, as the FBI does. When they've got a tough call, they don't convince each other what it says. It doesn't take them 700, 800, 900 hours to tease out something that's not there so they can put their scientific stamp on it and say, aha, this is my expert opinion. Dr. Nakasone uses a blind listening panel. They do whatever they do and then listen to it. And if it's there, it's there. If it's not, it's not. Dr. Nakasone was not allowed, under the scope of his TUI letter, to review the methodology of Dr. Reich or Mr. Owen. His testimony was limited to what he did and his understanding of the acceptance of various methodologies in the relevant scientific community. Does the court understand what I'm getting at?
I do.
Okay, that was clearly defined in a letter. I can provide that to the court as an exhibit. I just didn't think to do that. However, Dr. Nakasone's lab did the work at the request of the state in this case. Dr. Nakasone found 2.53 seconds of speech, meaning not that it were words that you could understand, not that it was suitable for analysis under any of the methodologies, just that when you cut out the noise, the masking, the overlapping, all you had left was 2.53 seconds of screams in a life-threatening situation. A life-threatening situation, the so-called death cries, is of no use to a real forensic scientist. There was testimony about what would be. Dr. French was clear about that. You need words, you need clear sounds, you need enough speech to be able to compare it to someone else. and you can find those bits and pieces. You can use your training in phonetics. You can use your abilities in with the computer software, if it in fact been developed to the point that it was reliable, to find these matches, to come up with a point where you may be able to render an opinion, but not here. And the experts that tried, Dr. Nakasone and his FBI lab, said you can't. Dr. French took it that next step, though, because he does have the forensic lab, and he wasn't willing to say, you know what, you have to have a certain number of seconds. Not everybody agrees with the FBI when they say it has to be a minimum of 16 seconds or 14 with permission. Although it's supposed to be phonetically balanced, Dr. French said, you know, it's a little more flexible than that. Because, for example, if he were trying to compare his voice with Mr. Mantai's, it would be an easier comparison if that was just the purpose. Dr. French had a British accent, Mr. Mantai doesn't. If you have enough speech and you have these clear markers, you can make the call relatively quickly. There's nothing in this case, though, that allows for that. Dr. French said, on age, could a 29-year-old have made the scream that Dr. Reich says, in his opinion, was stop or help? Dr. French said 50-year-old could make it. Not even sure it was a guy, if you will. That when someone is in a life-threatening situation, all bets are off. It's not helpful. You can't make anything. It's unfortunate. You know, Dr. French does 80% of his work for the prosecution. This isn't a guy that we found and hired because he has a reputation for working for the defense. I didn't know him from Adam till I started looking around in May, I guess. He has the lab, he has the people, he has the university experience, and he testifies all the time around the world. Admittedly, he has not testified in the United States. He's working on a case, apparently, that he's not testifying. But I would hope the court wouldn't hold that against him because he has been hired as a trainer by the FBI and the Secret Service. I think that's pretty good credentials, even though he hasn't actually testified here in the United States. And I would certainly hope the court would find him to be an expert and a member of the legitimate scientific community in voice comparison. George Doddington doesn't testify because that's not what he does. He gave that up 30 years ago. It's astounding that he made the trip to get here, frankly. He is the scientist's scientist. He started doing speaker identification and voice recognition in the 70s and has done it every day since. Mr. Owen, the expert that the state offers not only to convince the court of his own methods and methodology, but basically to legitimize this whole thing, to say that he's part of the scientific community that can do this, has a financial interest in this case. He gets paid every time somebody buys the software. He went on television promoting his software in connection with this case. In fact, in one of the exhibits, I have a copy of a YouTube interview that he did that I'd like to supplement on the record. The court can read it or can view it at its convenience.
Is it already in evidence?
I don't think it is, no.
Okay.
But it's where Mr. Owen was questioned by a national...
We're going to argue about facts, not evidence.
Okay. Sustain.
We'll get to that in a minute. So he has a financial interest. He doesn't have a PhD, he has a BA in history. He's only used this software for a little while. He's only testified once using this software. and he's not quite sure what version that was, and it was admitted, but it was in an uncontested matter, not involving screams. The reason there's confusion in the scientific community with Dr. Reich's approach to this and his findings is because the best scientists in the world can't figure out what he did. They can't figure it out from the report, and they can't figure it out from how he explained it. It's almost as if he turned it up really loud, and then he claims to be able to hear this stuff. But he admits in his report that even though you turn it up loud, it doesn't make the speech better. He talks about behavioral things from which he's not been qualified as an expert. He makes random associations not based in science to come up with some sort of conjecture and speculation that it's clear the scientists say is the product of examiner bias. He spent probably 1,000 hours on this. He's listened to it enough over and over and over and over again that he can convince himself something's there. And curiously enough, being hired by the state, that it all seems to be against George Zimmerman. The taxpayers have already invested more than $70,000, and he's not done yet. I think we should shut off the faucet.
Just a second. Your objection is?
The objection is that's another fact. It's not evidence. He said he hadn't added it up yet, and that was the testimony. What he said is he got paid $6,500 so far.
Right, so far.
That's not right.
Because he has not finished doing what he was doing.
Yeah, he charges $100 an hour, and he's got well over 700 hours in this case so far, with what sounds like another couple of hundred to go. He took this on himself, Judge. Nobody even asked him to do it. He just sort of saw this in the news and thought he would get interested and start spending all of his time on it. And then he was able to get hired by the Washington Post to come up with this assessment. That's the preliminary report you have there. And then on top of it all, he still doesn't really even have an opinion. It's all preliminary. He's not even sure he can come up with a definitive opinion. This is where he's gotten so far, and the trial has started. So, where are we? The state has the obligation to prove to this court that these are valid scientific methods that have been generally accepted within the scientific community. The automated speaker recognition software is not. There's been no testimony in this courtroom that that is an accepted method in the scientific community. It's not there yet. Dr. Nakasone said it's a couple of years on. Only Mr. Owens says that in this courtroom. And he doesn't know how it works. He has no clue. He doesn't even know that the literature that the company publishes is wrong. It's scientifically flawed. He doesn't know that. Dr. Reich doesn't use it at all. I think he made a disparaging comment, frankly, about that, because the suggestion was, oh yeah, you use a computer. But that wasn't for automated speaker recognition. His computer was for his spectrograms, which have been debunked. They've been around since the, 60s or 70s, and it's clear there is no such thing as a voice print. That's now what's accepted in the scientific community. And that no real scientist is using that now as the basis, as the only basis of speaker identification. So, let me have one moment.
Just a minute.
That brings us to Ramirez, if you will. As the court clearly knows and has studied the Ramirez case, there's really two parts, I think, to the new and novel aspect of this evidence. The first part, I think, is there a methodology which is generally accepted by the scientific community? And to some degree, oral spectrographic analysis has been around a while. The oral perception, the listening, the critical listening, has been around a while. In fact, Dr. French uses it, testifies about it. And the automated speaker recognition is starting to get some traction, although it's not there yet. So generally, there are some methods, there are 3 of them, for which there has been some acceptance in the scientific community. Dr. Doddington says, no way. You can't do it yet. He has a top secret clearance with NSA, and he says it can't be done yet. However, we have an additional issue here, and that is, even if you assume for the moment that Mr. Owen's software would be generally accepted, which it's not, or the oral spectrographic analysis method is generally accepted, which is highly in question now, or the critical listening alone, which we don't even have before this court, we have this application issue. And that is that under Fry, it's not just the method itself that has to be generally accepted, but its application to the facts of the case has to also be generally accepted. And if it's not generally accepted, then it's new and novel. And if it's new and novel, then the state has to prove that it's generally accepted. I know that sounds almost circular, but I think that's where things are in this case. In Ramirez, the court is aware toolmark evidence has been admitted in some form or fashion for a long time, whether it's the firing pin imprint on a shell casing, primer cap, or an ejection mark, or a screwdriver busting open a lock. That stuff's been around a long time. However, in Ramirez, the proposed expert claimed that he could specifically identify the marks made by a specific knife on some bone or cartilage. And that had never been done before. And they had several hearings, as you know. There's 2 or 3 Ramirez opinions. It had never been done before. And that application to those facts was new and novel. And it wasn't shown that that's accepted in the scientific community, and the Supreme Court properly rejected it. In this case, even if the methods themselves may be generally accepted, the application to the facts isn't. Every expert with credentials and history and a commitment to this scientific community, the people that have committed their lives to it and that are recognized as experts internationally, said it can't be done. So, if somebody did it, it's new, not just novel, it's breathtaking, it's earth-shattering, it's worthy of a Nobel Prize. So, if they did it, good for them. But Mr. Manti has to convince you that, in fact, they did it with a methodology that's accepted in the community, and that has not been done. There's no other expert being offered other than Mr. Owen and Dr. Wright to support their own opinions. That's the scientific reliability aspect, I think. The court well knows that the courtroom is not a laboratory. It's not the place for experiments. That the court also has to do a legal reliability analysis. That's under 403. So separate and apart from that, even if the court thought, well, maybe there's something to it, the court has to take a look at what the effect of the evidence would be on the jury. And would the prejudice outweigh the probative value, essentially? The court's familiar with 403. Or would it lead to confusion or misleading the jury? Submit that it would. Dr. Reich doesn't even have a firm opinion yet. He's all over the board. Nobody really knows what his methodology is, and he says all of these things that nobody else can find on these recordings, and they're all bad for George Zimmerman. Tom Owen listened to the recordings and extracted all of the shouts that he could find. I think he said there were 10, maybe, 10 distinct things. He put it all together, and he had a few seconds worth. He didn't find any of the things that Alan Reich did. In fact, he assumed, I think, it's fair to say, he assumed that the person crying for help was all the same person. Otherwise, he would have had to have sorted them all out. So and he didn't find, he listened to him, he amplified him, he did the stuff that one would expect a forensic examiner to do, and he didn't find any of the things that Dr. Reich did. So we have opposing state experts on the content of the recordings, if nothing else. Submit, Your Honor, that this is perhaps the most important evidence in the case. It caught the attention of jurors. Most of these jurors said they knew something about the recordings. Some of them even knew that we were litigating this issue, unfortunately, frankly, that they knew that. Some of them even knew that the court was going to have to decide whether the experts can testify or whether they can't. And then we hope, of course, that they can then disregard whatever it was, depending on how the court rules. This evidence must be excluded on 403 grounds. It's not helpful to the jury. It's going to confuse them. They're going to find nothing out of it that's helpful. And the minimal value that it could have, the minimal probative value that it could have, given the contradictions and the conflicts, the experts that will be flooding through these doors to testify, to no opinion. To Dr. Reich's no opinion. He's not done yet. Just preliminary anyway, and he probably won't get there because the recordings are too poor. At least he admitted that. And that Mr. Owen has a financial stake in it and a bachelor's degree in history. I'm going to sit down, Judge. I've been here a long time, and the court has been very, very patient, and I appreciate the opportunity to make this presentation. It's consumed a lot of time, so I know the court has spent its time productively, and I would ask the court, for all of the reasons stated, to exclude this confusing, misleading, and unreliable evidence.
Thank you very much. Response? Rebuttal?
Judge, I didn't see Rule 403 mentioned anywhere in the motion that's pending before the court. That being said, the accurate quotation is there is a substantial danger of unfair prejudice or substantially outweigh any probative value. That is, as I understand it, the actual law. This is not an acronym contest. Rule 90.702 is in place for a reason: scientific, expert, or other technical knowledge. One does not have to have a PhD to testify about something. I will submit to the court that the average mechanic doesn't have one either, but he can tell me how to set my ignition timing. Let's talk about the evidence briefly as opposed to what Mr. West wishes it was. Dr. Reich said he does have an opinion. His tentative, not preliminary, tentative conclusion is that the screamer is none other than Trayvon Martin. What he said was not finished yet is his analysis of the background conversation, and he's, remember, considering two recordings. That is the defendant's non-emergency call as well as the 911 tape. It is the non-emergency call in which most of that background information is referenced, and frankly, none of the other scientists have bothered to listen to that one. None of them.
I believe Dr. Boddington testified that he listened to it. In fact, he had gotten some software for amplification off of the internet.
Stand correct. He spent a couple hours listening to it at his desktop computer through those
Just
speakers.
for clarification, Judge, so we don't lose the point, Dr. French did that analysis in his lab as well on that.
Thank you.
In any event, as far as the discussion about the depositions or the ability to depose the experts or the scrambling, I will point out that if the defense didn't get started seeking experts on this tape until May, that's not the state's fault. Number two is, I will also point out that while Mr. Owen was actually, even at the court's request, voluntarily agreed to not only hold days open for his deposition, but reduce his fees to something that the defense had requested, which he did, they still elected not to depose him. This, despite the fact that the defense disclosed not one, not two, not three, but 4 witnesses, one of whom I actually spoke to the day before he testified, all within a week or so. So the idea that there is some kind of inability or insurmountable difficulty, I think, I'll let it speak for itself. Dr. Wright testified what his methodology was. If someone else couldn't understand that or disagrees with it, that doesn't mean that he didn't explain it. He explained it that he uses the oral spectrographic method. That's what he did in this case. He used it on his computer. As far as Mr. Owen, he said he'd used critical listening, which is part of the oral spectrographic method. He displayed spectrographs, which is part of the oral spectrographic method, and he also used computer voice recognition software, which, while the FBI doesn't agree that it is currently available for use, Mr. Owen told you the National Security Agency, the DOD, NCIS have all purchased it, all use it. It is something that's generally accepted for use. As far as the financial interest, I think Mr. Owen made it clear, if he has one, it is pretty minuscule, and he hasn't made hardly anything, and he only, in any event, I'll let the court recall his own testimony about that. The defense witnesses can come in and tell the court that they are smart guys, and they are. They cannot, however, speak for the entire scientific community because, frankly, they can't agree even on what that community is. They're interested right now in trying to define the vocabulary across communities. That is the main focus of their working group. That is what's going on, the development of these standards. I'm going to use the example of, to say that one need not be familiar with how to write a computer code in order to be able to use the computer program. It's the same thing that the DNA analysts confront every time that they're confronted with the question about whether they can construct or are familiar with the samples taken for the DNA population database. The Supreme Court of Florida has held they don't have to be. They just need to be generally familiar with how they operate. That's what's the same things going on here with people using computer software programs. You don't have to be a program writer to be able to use it and offer testimony about it. There's nothing in FRI that requires that. Finally, I'm going to point out that as far as the defense's experts and whether the defense wants this evidence admitted, I'll put it like this. The jury also told you that at some point in time they'd been hearing media accounts that there were witnesses who claimed it was the defendant screaming. If there had been any such expert who will come in and offer anything like that conclusion, they would have been here. It is for that reason the defense doesn't want this evidence admitted. And as far as trying to unring jurors' bells about what they've heard in the media, we've covered that. But that is as really a problem, if it is indeed a problem, is that there has been information put out there, and it wasn't by the state's experts, that supposedly there was an expert that said it's the defendant screaming. If such evidence exists, you wouldn't be hearing the defense complain that it didn't meet the FRI standard. So I say all that to say this, Judge. The evidence should be heard by the jury and let them decide, as the law generally is inclined to require. There was nothing wrong with the methodology either in what was used or how it was used in this case. What you have are some very diametrically opposed opinions about what conclusions to draw from the application of those things to that evidence. But what's new and novel about them is the idea that you shouldn't even try. The two experts that were hired by the newspapers and subsequently hired by the states at least did that. This jury should be allowed to as well. Thank you.
Thank you both very much.
May I respond briefly only to two factual matters, not legal ones?
You need to do your paper. Go ahead. She needs to change paper. Just a moment. Okay, thank you. It's 5:30. You want, if I let you respond, the state's going to want to respond. They had the burden. We had their argument, your argument, and their rebuttal. That's enough for the court in all due respect. I'm going to go home this evening and review my notes from the hearing beginning on June 6th, and hope and expect to have an order tomorrow. There are certain pretrial motions that the attorneys have requested the court hear in the morning, so we will be in recess until 9 a.m. and we will begin opening statements on Monday at 9 a.m. So I will see you all at tomorrow at 9 a.m. Court is in recess. Please be seated. Can I have counsel approach for one brief moment?
We ask the court to allow Mr. Zimmerman to waive his appearance for the hearing today. He's been here all day, as the court's aware, and he won't directly participate in these proceedings.
Okay, Mr. Zimmerman, are you agreeable that your appearance be waived for this rebuttal testimony of the Fry hearing?
Yes, Your Honor.
Okay, you may be excused.
Thank you. Sit down and follow Mrs. Zimmerman out, so I will see you
Okay.
in the morning.
And Mr. Mantine, you may begin.
Thank you, Your Honor.
Mr. Owen, can you hear me, sir?
Yes, I can.
All right, Mr. Owen, you were previously placed under oath, and you still are. You understand that?
That's correct.
Mr. Owen, I had requested that the court consider your testimony for rebuttal for some very narrow purposes. The first of those is, you recall during your prior testimony that you were asked questions about the process that was described by the defense counsel as looping, whereby the sample of the screams was alleged to be improper, that when added together. You remember that series of questions?
Yes, I do.
And do you remember that you were asked about whether you had verified whether that would cause a problem with the software recognition or not?
Yes, I did.
And did you check on that?
Mr. Nakasone with his Super APHIS database, which included voice material.
Have you and Dr. Nakasone recently appeared on, I'll call it, opposite sides of a different case?
Yes, several times.
Okay. And no other questions, Your Honor. Thank you. That is the scope of the rebuttal here.
Okay, cross.
Thank you. May I have that? Mr. Owen, this is Don West. Hi.
How are you doing today?
Can you see me and hear me okay from where you are?
Yes, I can.
Great. Let's talk about this document for a moment. The title of it is Comparison Parameters and Speaker Similarity Coincidence Criteria. Are you familiar with that document?
Mine says draft white paper voice recognition in law enforcement. Is that the document? Could you
No.
put up on the screen? Let me see the first page.
All right.
If
I'm
we're
going to
talking about the same
see
thing.
if I can hold it in a way that you can see it.
I'm not so sure what that is.
Would it help if I read any part of it, do you think? Do you have all...
Read-
Let me ask you
read the
this way.
Read the first paragraph.
I'll ask you this way. Do you have all of the paperwork that you provided to the state attorney's office in connection with this case?
Yes. Mhm.
The title of the document I'm referring to is Comparison Parameters and Speaker Similarity Coincidence Criteria. The first paragraph reads, the Easy Voice system uses two interrelating parameters of comparison, paren, first and second error types, close paren. The next paragraph begins with false rejection, FR, is a probability of error. Does that ring a bell?
The information rings a bell, but the document, I don't have it in front of me. I don't know which document exactly you're referring to.
The next paragraph says, is it clear that you didn't write this document? Is that evident?
I don't have it in front of me. I don't believe so. I thought I sent a document called Draft White Paper Voice Recognition in Law Enforcement because Mr. Wayman referred to Dr. Wayman referred to various illustrations that are in this paper on page that I'm looking at on page 3 and on page 2. Show me page 2 and page 3 on the screen there. And let me see if I can identify it.
I'm going to read the...
No, just show me the page, see if I can identify the pictures.
There's no picture on the second page. It begins with the title, The Easy Voice Biometric Analysis Algorithms.
We're not talking about the same document.
I'll skip a page. Well, let me skip several pages, actually, maybe because there's an illustration on this page. Of the document, it's page 7, and the first line on this in bold reads, Gaussian Mixture Models Based Method, GMM. And I'll hold that up for you.
My document here only goes to page 6. It's a different document.
I take it then you're unable to speak to this document or what it is?
Not without having it in front of me. Not at this time.
authored by you.
Okay, and your objection is?
Dr. Wayman, the testimony was that Dr. Wayman received this document from me. And there was some question, in fact, an issue raised by Mr. Manti about what document it was. And then that was clarified through some questioning that indeed that was a document that was provided to the defense by the state in discovery, which I then forwarded to Dr. Wayman. Dr. Wayman's testimony was, as I recall it, that because he received it from me and I received it from the state, he believed it to be connected with Mr. Owen. I do not recall him ever having said that he believed Mr. Owen wrote it. In fact, it was just that. This was a document he received in connection with Mr. Owen's testimony. He reviewed it, he commented on it, but never claimed that he knew that Mr. Owen wrote it.
Okay, and Mr. Manti has established through Mr. Owen's testimony here today that he did not write this document, so he may inquire as to why he had this document and why it was produced.
Judge, specifically, it was referred to and referenced as, during the testimony, as an Owen report, a report by Tom Owen.
You could clarify that.
Yes. You're talking about the document that was referred to by Dr. Wayman as a Tom Owen report?
That's correct.
And is it in fact a Tom Owen report?
Absolutely not.
Are you familiar with Dr. Wayman and Dr. Nakasone?
I wasn't familiar with Dr. Wayman. I am very familiar with Dr. Nakasone.
Okay. Have the two of you had occasion to cross paths in the past?
Yes.
What is your understanding of the relationship between Dr. Wayman and Dr. Nakasone, if any?
From what I understand, I believe that
Okay.
Mr. Wayman,
Wait,
Dr. Wayman...
could you
Just a
please-
minute, Mr. Owen.
No matter how loud I talk, he's not going to be able to hear me, I don't believe. Your objection is?
Relevant. What does it matter what his understanding of the relationship between Dr. Wayman and Dr. Nakasone might be?
Okay, I'm going to overrule on relevance.
Thank you. Mr. Owen, please continue your answer.
Is my understanding that Dr. Wayman was employed by his contractor, who was employed by the FBI to help? Yes, I did.
What'd you find out?
I found out that, first off, looping is a term that was used by Mr. West, not by me. That the software, if it's too short a sample, will not work. It'll throw a flag up and say...
Just a second, he can't hear
But
me.
Just a minute, Mr. Owen. Hang on, there's an objection.
What's your objection?
This is hearsay because this witness is now being asked to testify about what somebody else told him that supposedly is an expert. And I will have no opportunity to cross-examine whoever that person was. This witness has already acknowledged he's not, insofar as the software itself is concerned, doesn't understand the math behind it, and it's obvious by Mr. Manti's question that he sought outside counsel of some sort. So I object.
Response.
Actually, Mr. Owen has not acknowledged that he's not an expert. In fact, I think he's to the contrary, but that aside...
No, I think that what Mr. West meant was an expert in that software.
As to whether or not he can program it, I believe he admitted that he could not do that.
Okay.
I agree with the court. However, the reason that this should be admissible is in rebuttal to the allegations that he had not, that he had talked to the improper person before. In other words, it was used before in that very context, and so I believe I should be allowed a fair response to that, even if the matter is technically hearsay, because it's in response to hearsay elicited by defense counsel.
Okay. When you have hearsay and there's no objection, the court doesn't have to make a ruling. When there is an objection based upon hearsay, the court has to make a ruling. So since something may have come in that may have been hearsay and there had been no objection to it, doesn't mean that you can't now make an objection to hearsay. So Mr. Owen cannot testify as to what his conversation was because Mr. West would not be afforded the opportunity to cross-examine that person who gave him the information Thus, Mr. Owen's interpretation of the conversation is what the court would hear, and I do not feel that that is proper, so I will sustain a hearsay objection.
Yes, Your Honor. I'll move on to the next section then. Mr. Owen, do you recall the series of conversations that were had the last time you testified regarding, well, did you have occasion to observe the testimony of Dr. Wayman, who testified in the last section of this hearing?
Yes, I did.
Do you recall seeing that he was shown some sort of paper that was purported to have been authored by yourself?
Yes, I did.
Okay, and do you know which paper it is we're talking about?
Yes, I did.
And was that authored